Do you need letters testamentary for probate administration? Imagine you've just lost a loved one and now you're faced with managing their estate. You might wonder what steps are needed to handle everything legally. One key document often comes into play called letters testamentary. But do you really need them? Let's break it down. Letters testamentary are official papers issued by a probate court. They give the person named in the will, called the executor, the legal power to manage the estate. Without these letters, banks, government agencies, and other institutions usually won't let the executor access or control the deceased person's assets. If the person left a valid will and named an executor, then yes, letters testamentary are typically required. The executor must file a petition with the probate court showing the will and the death certificate. Usually, there's a court hearing where the judge confirms the will's validity and appoints the executor. Once approved, the court issues the letters testamentary. Now, if there's no will or no executor named, then the court will issue letters of administration instead. These are for situations where someone needs to be appointed to handle the estate because there is no designated person. So, letters testamentary are specifically for estates with a valid will and a named executor. Probate is often necessary to validate the will and get these letters. However, some small estates or assets held jointly or in trusts might avoid full probate. But generally, if you want to settle an estate properly, you will need the letters testamentary. Getting these letters is a straightforward process. First, gather the original will and the death certificate. Then, file a petition with the probate court asking to open probate and issue the letters testamentary. After that, attend the court hearing where the judge reviews everything. If all goes well, the court will issue the letters testamentary, which legally empower the executor to act. It's wise to request multiple certified copies of the letters testamentary because many banks and agencies will want to see the original or certified copies before releasing assets. Hiring an estate attorney can help make this process smoother and avoid mistakes. In summary, if you are named as the executor in a valid will, you will almost always need to obtain letters testamentary from the probate court. These documents are essential to legally manage and settle the estate. Without them, handling the estate's assets, paying debts, and distributing property can become very difficult.